Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and this morning I'm looking at another book from the Common Law Library from Sweet and Maxwell. It's the one on contempt. It was known as, and is still known as, Arlidge, Eady and Smith on Contempt, now in the 5th edition. It's got some new general editors, Patricia, Londono, David Eady, of course, who will be known to many of you, Professor A.T.H. Smith, also very well known, and Lord Eassie, who covers the Scottish jurisdiction. Now, this is part of the Common Law Library from Sweet and Maxwell, THOMSON, REUTERS, and I've given the title for our review the following: The Common Law Library remains as refreshing as ever, with the new edition on contempt laws. Now, I'm going to just show you the book first of all, and we can have a look at it. It's a heavy book. I'm very used to these books, I have to say, because they've been a lifeline for me. There is the book itself. There is the spine. There's nothing on the back. You can see the spine. Common Law Library, Sweet and Maxwell, 5th edition. So you've got that. It's a very heavy book, as they all are. These are expensive books too. It runs to nearly 1,600 pages, in fact, in total. That's the index at the back. You can see the structure. Falls in line very much with the house style of Sweet and Maxwell. This is paragraph numbering. It's a detailed index as well, and it follows the legal taxonomy route which Sweet and Maxwell have set up, which means that they've designated titles for particular substantive law areas, if you like, as tags, so you will know, because it's standardised, where to find things. Then you've got examples of penalties imposed since 1981, an interesting area there. Again, basically looking at what the Court of Appeal have done. Now let's just look at the front of the book. There's the front of it. That is the list of the Common Law Library publications. I've reviewed all of them over the years. They are the definitive work. I'll say a bit more about that in a minute. That's the front sheet there. Then you've got some more blurb about the book itself. Came out in 1982. There are the 10 contributors. I'm going to name them because they've worked very hard. Aidan Eardley, David Glenn, Clara Hammer, James Hayton, Ian Helm, Claire Kissin, Sarah Palin, Hannah Reddy, Jonathan Sherbel-Ball and Kate Wilson. Thank you all very much for what you've done. The preface is worth reading just to keep you up to date with what's been happening, because there's been a lot taking place. Then the table of contents, very detailed, because there's a lot of information. Then we have a very large amount of case law. I'm not mentioning any cases in the review because there are a lot of new cases which have come up. So you've got a lot of cases. Then after that you've got the statutes, of course. Then after that the statutory instruments. And then after that the CPR, because there's a new CPR, which I'm going to mention that again in a minute as well, CPR 81. Then you've got the table of international legislation there. Then the rules of the Supreme Court, the old rules from the very old White Book. Years ago, I remember that. Now, chapter 1, you see how it's structured. You've got a little index for the chapter. It's very helpful to find things very quickly. Then you've got the paragraph numbering at the side there, and you do, of course, have extensive footnoting. And as I say, it's a very substantial work. Injunctions, contra mundum, there we go. You get an idea of what it's looking at the centre of the book. Protection for juveniles, there we go. In fact, that's the 1933 Act, so it's a very old piece of legislation, of course, that one. And much, much more. I say that because I think these books are wonderful. There's no question in my mind about it, and that's why I always review them. This is where the law is. I use these for my opinions, my skeleton arguments, especially if there's something where the client is adamant about a particular thing and you may need some really heavyweight authority. Remember, you've got people right at the top of the legal world who are writing this book, and they know what they're talking about, because this is where the law is. So this is what I'm saying actually about the library and everything else to do with it. One of the most enduring aspects of the top level legal works is Sweet and Maxwell's Common Law Library, and I make no bones about that, and I'm sure everybody will agree. It remains at the highest of the highest authoritative value as legal publications. That's the library itself, for the judiciary, lawyers and academics. And if you want to identify where the law can be found on any major area of substantive importance, look no further than this library of books. And as I said, there's a list of them at the front. And it remains the case, especially here, with the 5th edition of the Law of Contempt, which came out originally in 1982. Been with us for a while. Obviously, the first book came out because of the legislation, and it's run along since as society has changed, because it's had to take account of a lot of changes, which I will come on to, because the new edition appears some 5 years after its predecessor, at a time of substantial technological change, particularly with regard to the role of the juror. Because as the editors write, there has been a resurgence of interest in those who have, in various ways, by their actions, undermined the integrity of trial by jury. And we see a lot of this in the newspapers and television programmes as well, interviewing jurors. So you see what the problem can be. Now, therefore, the editors have included some most useful commentary on recent case law authorities, both here and in Europe, looking at this and other major changes in the law of contempt. And of course, the temptations of the internet will remain as real concerns for the judiciary, plus the ever-present issues of matters such as the Human Rights Act, the human rights issues themselves, which are of course very well covered in the new edition, which has incorporated all of the supplements since the 4th edition. And they do stress that point, and I would, that remember, when you buy this, you're getting the supplements, you're getting a supplementary service, so they are updated, as it's a note-or-up system, a little bit like Hallsbury and various other things. And it is very, very useful to have that, because sometimes the law will change. And it's happened to me. I go to court and I think I've got everything, and suddenly someone says, "Oh, do you know this new case?" And I don't. So you can see what the problem can be. Now, we found the information, and I'll take one area, on reform of the Law Commission, reforms from the Law Commission, very enlightening. And that's specifically their reports on contempt, number 335, which covers the dead letter subject of scandalising, which most people have thought had gone, but it hasn't. Now, their report dealing with contempt on the face of the court, unfortunately, of course, has been delayed, but will presumably be resurrected for a future edition of what remains to be a most impressive work. We'll look forward to that, because I cannot see even now that this subject is going to remain static because of the way we are going with all sorts of developments, mainly technological, I hasten to add, and of course attitudes, because people's attitudes have changed a bit too. Fortunately, we've also got a very useful commentary on the most important significant development, which affects civil procedure. They do obviously cover criminal and civil procedure in tremendous detail, but the civil procedure area is part 81 of the CPR, and that is well handled, I think. The editors state that open justice has been a continuing theme, especially so with family matters and the protection of journalist sources, to name but two. Now, the text has been revised to include a number of new practice directions and other guidance, which we've also found most useful, and they cover matters like access, reporting restrictions, and the publication of judgments, which will be of particular interest to many readers. And for the first time, more consideration is given to the access and availability of visual recordings at a time when IT is progressing at a very fast pace. I make no apologies for stressing this point, because it's going to come back, I'm sure. The preface to the book makes some important observations about visual access, although it is of course confined to the higher courts at present. Being to the Supreme Court is wonderful. Everything is filmed, you've got cameras. The problem is that the media are only going to take a very short chunk of it, rather than the very long time it takes to get a case heard. And it's very clear from certainly our point of view, and that I think of many colleagues, that this area will require another visit for the next edition, when the 4th Industrial Revolution really hits the legal world. Hasn't really started yet, but when it does, we are in for a lot of change very quickly. Now, there's a final word of warning, I think, here as well. Most proceedings we are involved in are slow-moving and technical, so that there is little to hold the attention of the casual onlooker. Now, the advice or approach that they're giving here, which I think is very sensible, is that the presence of cameras does not intrude upon or inhibit the court process. And that is very important. That was a point that the retiring Lord Chief Justice, Lord Thomas, made to me and to others when he had taken decisions to slow the amount of time it would take for us to introduce the cameras into even the higher courts. They are coming, but it's a slow process. So rightly, protection has got to be afforded to those who may not be able to cope so well with such distractions. And in essence, after comments from experiences in the New Zealand courts, it will be a slow process, but probably inevitable. And I say that because it's only recently I had a case in court where the judge was saying the new generations of people coming up expect to see things which are recorded visually, and the reading is obviously important, but it's not necessarily the be-all and the end-all of it. And whilst I'm an old guy who looks at it in a slightly different way possibly, those new millennials who are coming up, to use the expression, very offensive it is too in many people's views, but those younger people today are looking at things with the use of technology in a totally different way, and that will have to be taken account in new editions, which I'm sure it will. Let me conclude by saying this, because I love the book and I love the series of books in the library. There's a team of 10 additional contributors to help the editors, and they make the new edition as complete as it can be, and they, together with the editors, I think, have made this work the definitive authority on contempt at a time of change. We can't do our work as practitioners without these books, so thank you all very much indeed for what you've achieved here and what you do for us. It's appreciated. The publication date is stated as at the 23rd of May 2017. So the law basically is as it is then, although there are the supplements which will of course give you additional information. Let's look at the book finally one last time. There it is. Spine. So nothing on the back. It's a heavy book. Well, not surprising for 1600 pages. Contempt committed by jurors. I can't just just open this. There it is. Just at a suitable place. You can see it shows the paragraph numbering. You've got your footnotes and everything else. And generally speaking, this is, I think, a very important area. It's an area of interest to everybody, and we're going to have to start looking at it very carefully. There will have to be proper rules, and there must be guarantees for everybody concerned. Finally, thank you again to everybody concerned. The law library is very, very important to me. I started my legal training in 1970 with Chitty on Contract, and I've never forgotten since then the clarity of the book and how useful it was, because it was the authority. That's what these are. Thank you to all. Bye-bye.